In this lesson, what I'm going to do is move on away from looking at the basic principles and sources of the English legal system and start to talk about the court and judicial system that exists within the English legal system. And this means we're going to talk about the general structure, role, and powers of the judiciary. We'll take an introduction to the judiciary in this lesson and then talk about the ways in which appointments are created, the ways in which independence is assured by the judiciary, and also the ways and the powers and the roles the judiciary play in the general running of the English legal system and the general running of law in the England and Wales. So this is moving away from the more theoretical, substantively legal principles that we've been talking about previously, and towards some of the more structural components of the English legal system and the English adjudication system. It means an examination of the system of courts and judicial institutions in England and Wales. Now, the word judiciary is just a collective term which refers to all of the judges who sit in courts in England and Wales. The main aim of the judiciary, as you may understand already, is essentially to hear cases, to hear disputes, and to adjudicate on those disputes in a fair and neutral manner. The general view here, therefore, is to apply law to facts, to apply law that has been passed by Parliament and has been established by previously understood precedents to the facts of new cases which have been brought to them. Now, the judiciary is divided into numerous different levels of courts. You have a main distinction between the superior judiciary and the inferior judiciary. Now, this is not to suggest that one's better than the other, but it suggests that some have more authority than others. Beginning first then with superior judiciary, or the superior judges. A superior judge is an individual who sits on some of the higher courts which exist within England and Wales. The higher courts include the Supreme Court of the United Kingdom. As the name may suggest, it is the supreme ultimate law adjudication authority. The Court of Appeal, as well as the High Court. These are all representative of superior judicial appointments. Inferior judges, on the other hand, are those who sit in the lower courts and will sit and adjudicate on matters of law which are seemingly given to be more trivial in some cases. These include, for example, circuit court judges, as well as Crown Court judges, and county courts, as well as magistrates' courts. Now, this is not to suggest that not all of these courts don't deal with very significant and very important cases, but in terms of matters of law, the superior judges have more authority in the interpretation of legal precedent than these judges do down at the lower levels. Now, when it comes to the selection of judges, the original process by which a judge would have been selected to serve on the judiciary was through and under the remit of the Lord Chancellor. The Lord Chancellor would do a secret selection process. Now, the Lord Chancellor is a role and a position that has changed quite significantly, namely post the constitutional changes that were made under the Blair government of New Labour. But one of the things that the Lord Chancellor was, which was quite controversial, was a member of the cabinet. So it was seen as something of a politicisation of the appointment process. Since the Lord Chancellor was a political appointment, the Lord Chancellor also had roles in the legislative branch. They were the Speaker of the House of Lords, but they also had roles in the executive branch. They would sit in cabinet and make decisions on that basis as well. All of these things aren't the best for looking at judicial independence. One of the reasons for this is because one of the things that the government does quite a lot is be taken to court. Court decisions are often done, at least when we talk about things of a constitutional or an administrative law matter. These are cases which involve, in a lot of cases, the government. And so if you have a government-appointed set of judicial appointments appointed by the Lord Chancellor, then it is seen as a politicisation of the process. It should be something of an independent process. As such, the Constitutional Reform Act of 2005 made a number of reforms to the process of selecting judges. First of all, it made a reform to the role of the Lord Chancellor in its entirety. The Lord Chancellor no longer sits in all three branches of government. This was seen as a violation of the separation of powers. So the fact that the Lord Chancellor was the head of the judiciary, was the Speaker of the House of Lords, and also was sat in cabinet, was representative of an individual position which could have authority and power in all three branches of government. So, as a result of which, the Lord Chancellor was removed from some of these positions. In addition to this, the Constitutional Reform Act of 2005 removed the role of the law lords in the House of Lords, and they moved those individuals across the square to the old Middlesex Hall and created the Supreme Court, which would ultimately be opened in 2009. But apart from those two things as well, the Constitutional Reform Act of 2005 also established the Judicial Appointments Commission, the JAC. Now, what the Judicial Appointments Commission essentially did was represent something of an independent commission tasked with the job of appointing new judges to the judiciary. The JAC hasn't removed the role of the Lord Chancellor in the appointment of new judges, but rather what it does is takes the role of interviewing, vetting, and selecting potential candidates for recommendations to the Lord Chancellor. So rather than the Lord Chancellor making the position and making the decision on who gets the position themselves, what the JAC does is essentially gives the Lord Chancellor recommendations on the basis of the independent appointment process, for which the Lord Chancellor can then make recommendations to select judges to the judiciary.